Mr. Speaker.
Kelvin Davis.
Thank you, Mr. Speaker, and I rise to speak on the electronic monitoring of offenders legislation bill, which the Labour Party does support. It amends 3 acts: the Corrections Act 2004, the Sentencing Act 2002, and also some amendments to the Parole Act of 2002. I think just to clarify the situation for the House and for people listening, I'd just like to go through the matrix that Corrections has provided to the Law and Order Select Committee that describes when different electronic monitoring systems need to be put in place, because it is quite confusing. So when someone is found guilty of a crime, the least restrictive punishment before they are sentenced is that they are bailed into the community. The next most restrictive is that they are bailed, or they receive electronic bailing. So they go out into the community still, but it's electronic bail. Then the most restrictive is that they are remanded into custody. So that's all before they're sentenced, and the court does that sentencing. And then the least restrictive of the sentencing is community work, and most people will know that as PD. When I was the principal at Kaitaia Intermediate School, every 6 weeks or so we'd get the PD gang to come and to help tidy up the school, the gardens, and do various jobs. Basically that is so that they atone for a minor crime they may have committed in the community. The next step is supervision. So if there's supervision, it's community-based rehabilitation sentence that requires offenders to address the causes of their offending. The next step up is intensive supervision, and we are looking to bring electronic monitoring in some cases, into intensive supervision. So intensive supervision is a longer sentence, and it involves attending programs to address issues that led to offending. The next level up, we're getting more severe now, is community detention, which is basically a curfew that requires electronic monitoring. So somebody might still be able to go to work, but between the hours, say, of 7 p.m. to 7 a.m, they have to be at a certain residence, or they might, the curfew might mean they're not allowed to go near other people or other places. The next step up is home detention, where somebody is in a residential, has residential conditions where they have to stay at a residence basically 24/7, maybe with an hour out each week to go and do the shopping or go to see the doctor or pay bills or whatever. Then after home detention, the next most serious sentence is a term of imprisonment for less than 2 years, which is pretty self-explanatory. The next most serious is a term of imprisonment greater than 2 years. And then only the court can impose those sentences. The next part of an offender's journey, I guess you could say, is the release in the post-sentence order. The least restrictive is the post-detention conditions. Then going up a scale is release at half of the sentence term, and they have conditions with that. Those are imposed by the court. And then the next level up is parole release conditions imposed at the sentence expiry date, and that's imposed by the parole board. And this is another one of the areas that we're looking to, actually in this case, beef up the electronic monitoring. Above that are extended supervision orders, where offenders who, mainly highly violent or sexual offenders, need to be highly monitored once their sentence is over and they're back in the community. And then public protection orders are another step up again. So that matrix, I think, is really important, because when you have all these different orders, and many of them sound very similar, such as an intensive supervision, which is a sentence, and then you have extended supervision orders. It's easy for people to get confused as to where everything sits. But the thing with the electronic monitoring, it does work if it's done well. And the basic reason for it is to make sure that people are where they should be. If they are subject to conditions of electronic monitoring, the bracelets, ensure that the person is where they should be. But it also raises an alert if the person ends up somewhere where they shouldn't be. It raises an alert. The next thing is that the electronic monitoring can provide evidence to show that the person was in the wrong area. So it's one thing to get an alert and the person absconds and ducks off somewhere where they shouldn't be, but then comes back. The electronic monitoring bracelet can be used, the GPS tracking can be used to show that they were somewhere where they shouldn't have been. And then you can also use the bracelet, I'm not sure how this works though, to make sure that the person hasn't tampered with the electronic monitoring device. The reasons for electronic monitoring are to make sure that if somebody has committed a crime and has a condition where they say shouldn't associate with gang members, that'll be part of the conditions. This bracelet can tell whether or not they've gone near a gang residence, or they might not be allowed near a school or near a park, or they might not be allowed there at certain times of the day. So that's what the electronic monitoring does. The thing with electronic monitoring, though, is it's only as good as the monitoring. So we've heard over the last couple of months, actually, about a number of offenders who have cut off their bracelets. And it's good to hear that the Minister has ordered 1,000 of these new tough electronic bracelets from somewhere, and that they're going to be used. Because as it stands right now, an offender can basically walk down to the nearest warehouse and buy a $2 pair of scissors and cut off the bracelet. Now, we heard in the last 2 days too that on any given day there's something between 20 and 47 offenders who have removed their bracelet and are running around somewhere in a community, somewhere. The government had tried to downplay that by saying, well, 47, that's less than 1% of all the offenders who have got bracelets. Well, you know, they shouldn't downplay that, because that means there's somewhere between 20 and 47 communities that don't know where somebody is running around in the community. That's 20 to 47 communities that are living in fear. If you take a community like Kaitaia that has a population of about 5,000, that means there's just under 200,000 people are in New Zealand who are living in fear. They don't know where an offender could be at any particular time. So I don't think the government should downplay those numbers. It's very serious to the people who are most affected, that is all the communities around New Zealand, because right now they don't know where these people are. They don't know where they're running around. Most of them won't go and commit a crime, but we don't know which ones of them won't go and commit.
I'm sorry to interrupt the honourable member. The time has come for me to leave the chair. Members, this debate is interrupted and set down for resumption next sitting day, and the House stands adjourned until 2 p.m. tomorrow. Good evening.